I think we're done, so we're gonna start now.
My Lord, I have one submission to make, that Dr. Barnes is a public authority carrying out a public function, hence eligible for judicial review under the following points. A. Dr. Barney's function was a public function, hence they are subject to judicial review. Dr. Barney's was performing the same function as the council had been performing before they took over. As such, it stepped into the shoes of its predecessor, a public body. Dr. Barney's was a high to the public function they carried out, even though they were not a core public body. The function of Dr. Barney's was so close to the function that was carried out by the council before that now, Dr. Barney's is considered as a functional public authority. If it please your lordship, I would offer the first point of my submission. Shall I proceed?
Yes.
That Dr. Barney's function was a public function, hence subject to judicial review. I refer your lordship to the case of the Crown Panel and Panel on Takeovers and Mergers, ex parte Data Fin, Private Limited Corporation and another, 1987, Queen's Bench, page 815, found in Divider A, Green tab 1, paragraph C. Does my lordship have sight? Does my lordship require a brief summary of the facts of the case?
Well, firstly, I'd like to know why you're relying on a judicial review case. Is this not an action under the Human Rights Act?
Indeed, my lord. However, I have the respondents are trying to prove that it's a public body so that judicial review can take place.
But isn't a public body, the concept of a public body, also one that is set out in the Human Rights Act?
Indeed. However, in the previous case, it was overturned that Dr. Barnes was in fact not a public body.
Right. So you mean in the Court of Appeal?
Indeed.
Right. And will you be adducing any cases that directly apply the concept of public body found in the Human Rights Act? So, in terms of your arguments here, you're arguing that the concept of public body in judicial review is analogous to public body in the Human Rights Act. Or have I misunderstood the issue?
Indeed it is, my lord. Forgive me.
So we have to, so perhaps we should go back a bit, and when it comes to the facts, what is it exactly that you're trying to establish? You're trying to establish that Dr. Barney's is a public body for the purposes of what cause of action?
For the course of, it establishes that it is a public body under Section 6 of the Human Rights Act, 1998.
Okay, right. So by analogy, you're using these cases, right?
Indeed.
Okay. So just brief, I'm familiar with the facts of data fin, and I've got sight of the bit that you now want me to have a look at.
Should I proceed?
Yes, please.
My lordship, I quote the judgment of the trial judge, Lord Justice Lloyd, found on page 847. I quote, "If the body in question is exercising public law functions, or if the exercise of its functions have public law consequences, then that may, as Mr. Lever submitted, be sufficient to bring the body to within reach of the judicial review. This reflects the fact that since Dr. Barney's ran the residential homes previously run by the council, they were in fact exercising public law functions." Does my lordship have any questions?
Yes, isn't the argument here circular? Because it says that if something's exercising a public law function, then it's a public body. But that presupposes that it's a public law body, a public law function. So what is a public law function?
The public law function is a function that is public in nature, and the government receives an advantage out of it.
Okay, thank you.
Should I proceed?
Yes, please.
If your lordship has no further questions, I would like to proceed with the second part of my submission. Dr. Barney's was performing the same exact function the council had been performing before Dr. Barney's took over. As such, it stepped into the shoes of his predecessor, a public body. May I draw my lordship's attention to the case of the Crown ex parte beer trading as Hammertrout Farm and Hampshire Farmers Market Limited, 2004, Volume 1 Weekly Law Reports, page 233, found in Divider A, Pink Tab 2, Section F. Does my lordship have sight?
Yes.
Does my lord like a brief summary of the facts of the case?
Yes, I would.
Hampshire County Council, a local authority, appealed against a decision allowing Mr. Beer's application for judicial review of a decision by Hampshire Farmers Market Limited, a limited company established by Hampshire County Council. Mr. Beer contended that the decision refusing him a license to participate in the farmers' market, whereby local produce was sold to the public from sites owned by local authorities, was susceptible to judicial review. May I draw my Lord's attention to the trial judge, Lord Justice Dyson, on page 248, who explained the meaning of stepping into the shoes. I quote, "It connotes the idea of A, performing the same functions as had been previously performed by B, to the same end and in substantially the same way."
And B is the public authority.
Indeed. My Lord, this extract displays that Dr. Barnes did in fact step into the shoes of the council when they took over the council's exact functions. Does my Lordship have any questions?
No.
If it pleases your Lord, was a hybrid public authority due to the public function they carried out, even though they were not a core public body.
How can it be both a hybrid public body and stepping into the shoes of a core public body?
Due to the fact that they also carried out, they were also a private body
Right.
that carried out some private functions as well.
Are you talking about Dr. Barnes?
Indeed.
What private functions do they carry out?
They were also employing employees to take care of the children as well, according to the facts.
Okay,
Should I proceed?
yes. So let me be clear. What is it that you consider here, I mean, if we take a step back, what is it here that you consider to be a public function?
They were hired by the county council
Yeah.
to run the residential homes for the children and to take care of them.
Okay, thank you.
May I direct my Lordship's attention to Divider A, Yellow Tab 3, Section D. On page 555.
Yes.
My Lordship, I refer to the case of Aston Cantlow and Wilmcote with Billesley Parochial Church Council and Wallbank and another, 2004, Volume 1, Appeal Cases, page 546.
Yeah. Mhm.
Is my Lordship acquainted with the facts of the case? I quote Lord Nichols of Birkenhead, who defined public functions. I quote, "Factors to be taken into account include the extent to which in carrying out the relevant functions of the body is publicly funded, or is exercising statutory powers, or is taking the place of central government or local authorities, or is providing a public service." May I furthermore draw my Lord's attention to Yellow Tab 4, Section C?
This is a case, this is a human rights case, isn't it?
Indeed.
Okay.
Yellow Tab 4, Section C on page
Okay.
556.
Mhm.
I quote, my Lord, "I turn next to consider whether a parochial church council is a hybrid public authority. For this purpose, it is not necessary to analyze each of the functions of the parochial church council and see if any of them is a public function. What matters is whether the particular act done by the plaintiff counsel of which complaint is made is a private act as contrasted with the discharge of a public function. My Lord, I submit that these extracts reflect that Dr. Barnes was in fact a hybrid public authority due to the public function that they carried out as a private body. Does my Lord have any questions?
Yeah, I'm still not clear what in your submission is the difference between a hybrid public body and a core public body, and why in this case, which one you're arguing Barnes is? Dr.
In my
Barnes
case,
is.
I'm arguing that Dr. Barnes is in fact a hybrid public body.
Right. Okay, so what's the, so these tests for a public authority that Lord Nichols has set out
Indeed.
state what should be considered a public body.
It was used to define public functions, my Lord.
Okay, to define a public function.
Yeah.
So from the bits you're quoting to me, I do not see how this makes it a hybrid body. Surely it makes it a purely public body. Where I don't see where the hybrid bit comes in.
As I stated before, due to the facts of the case,
Yeah,
it's assumable that they had some private functions as well.
I see. Okay, so it's an assumption.
It's an assumption.
Okay, fine. Carry on.
If my Lordship has no further questions, I will move on to the final point of my submission.
Okay.
The function that Dr. Barnes was the function of Dr. Barnes was so close to the function that was carried out by the council before that now, Dr. Barnes is considered a functional public authority. I refer to the case of Poplar Housing and Regeneration Community Association Limited and Donahue, 2002, Queen's Bench, page 48. May I refer your Lordship's attention to Divider A, Blue Tab 5, Section D on page 50. Does my Lordship have sight?
Yes.
Is my Lord acquainted with the facts of the case?
Yes.
I quote from the trial judge, Lord Wolf Court Justice. My Lord, I quote, "The role of Poplar is so closely assimilated to that of Tower Hamlets that it was performing public and not private functions. Poplar is therefore a functional public authority, at least to that extent." My Lord, does my Lord have any questions? My Lord, it is for these reasons, and those that will be given by my junior counsel, that I urge you to allow the appeal. If your Lordship has no further questions, that concludes my submission.
I have a few. I mean, this is the Supreme Court. We have these decisions, some of which are from this House, some of a lower house. We look at the factual scenario here, and we look at societal developments, and we see that there is an increasing trend towards contracting out certain government functions. Now, why should we, as a matter of policy, continue down the line that you've advocated and that you've provided authorities? Why should those private entities be bound by human rights legislation?
Due to the fact, in case that human rights acts are violated
Yep.
within their functions, my Lord.
I know that. What I'm asking is, why should they be? Why should a private company like Dr. Barney's be subject to what is essentially a public law standard?
Due to the fact that they were performing public functions, they should be bound by administrative and public law.
So what's the underlying philosophy then? Because if the government contracts with a private entity, it is essentially saying that we the public function don't need to do this. We the public authorities don't need to do this. There doesn't need to be a public ethos or a public protection. This can be done by the private sector. So I'm trying to understand philosophically why we should be giving those type of companies the same burden that they may not expect to have.
Because I believe that private bodies can actually carry out government functions better sometimes due to the funding that they have access to.
Okay. And is there any other basis on which you'd establish that?
No.
Thank you very much.
Thank you.
May it please your lordship, my name is Nasreen Mariam Abuin Shah, and I appear as junior counsel representing the appellant. If my lordship has no further questions, I shall proceed with my submission.
Sure.
I submit the fact that my learned senior established that Dr. Barney's is in fact a public body, and therefore their actions were in fact ultra-virus and therefore illegal. By referring to the case of Council of Civil Service Unions and others, and Minister for the Civil Service 1985 Appeal Cases, page 374, which my lordship will find under Divider B of the Bundle of Authority, Green tab 6, section D and G highlighted in green, page 410. Does my lordship have sight?
Yes.
Would my lordship like a brief summary of the facts of the case?
I would prefer not. Thank you.
I'm obliged. I quote my lordship, Lord Diplock. Judicial review has, I think, developed to a stage today when, without reiterating any analysis of the steps by which the development has come about, one can conveniently classify under three heads the grounds upon which administrative action is subject to judicial review. The first ground I would call illegality, the second irrationality, and the third procedural impropriety. Furthermore, Lord Diplock defined the meaning of irrationality. By irrationality, I mean a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived at it. This reflects in the case of Andrew Brown, the appellant, where Dr. Barnes applied irrational behavior by frequently punishing the appellant by locking him up in his room for long periods of time and denying him meals. If my lordship has no further questions, I would proceed with my next point of my submission.
Could you summarise your main submissions before going into, just so I know where you're going?
Yes.
Yeah, very briefly, if you may.
My submissions are divided to the fact that the appellant was tortured.
Okay.
He was treated degrading, and it was inhuman behavior of the respondent to treat the appellants in the way they did.
Okay. And you will argue this on the basis of irrationality and on the basis of what else?
I will argue this on the basis of irrationality, as my lordship mentioned.
Yeah.
And I will highlight this by mentioning also cases from the European Courts of Human Rights referring to Article 3 of the European Human Rights Convention.
Yeah.
And to try to underline the outrageous behavior of the respondents.
Right. Okay. And will you be dealing with the deprivation of family life?
Yes, my lordship, but very briefly, since in our opinion, this is not the main focus. It is more essential that the appellant was deprived from his human rights, which includes Article 8 being deprived of family.
Right.
But considering personal injury, it is our feeling that it is more necessary to focus on Article 3.
Okay. Sure, carry ahead. Go ahead, please.
I'm obliged. By referring to Attorney General and Fulham Corporation, 1921, Volume 1, Chancellery Division, page 440, which my lordship will find under Divider B, pink tab 7, highlighted in pink.
Sorry, going back to irrationality.
Yes.
What's your argument as regards the treatment and irrationality? So you're saying no reasonable authority could have treated anyone that way?
Yeah, yes, my lordship. By applying Lord Diplock's quote to the actions which were put on our appellant, we suggest that the irrational behavior consists in frequently punishing the appellant in different circumstances by locking him up in his room for long periods of time and denying meals, which consists to be very irrational and depriving the appellant of his human rights under Article 3. May I draw my lordship's attention to the case Attorney General and Fulham Corporation, 1921, Volume 1, Chancellery Division, page 440, which my lordship will find under Divider B, pink tab 7, highlighted in pink, pages 454 and 455. Would my lordship like a brief summary of the facts of the case?
Thanks.
Obliged. My lordship, I quote Judge Sargent. However, this is not the real point on which the matter turns. The matter turns on this: whether or not the council has, either expressly or impliedly, the power to conduct the operation it is conducting. In my judgment, neither expressly nor impliedly under the acts which it relies has it the power, and accordingly the plaintiff is entitled to succeed. According to this, my lordship, I put it to the court that Dr. Barnes, by depriving him of his human rights, has gone beyond the powers conferred to them by the Children's Act of 2000, and therefore can be considered ultra-virus and therefore illegal. Does my lordship have any questions?
So what's the precise obligation that you're saying is breached under the Children's Act? Because my understanding, and you can obviously correct me, is that the issue there is whether or not, is simply whether the local authority can delegate the responsibility of taking care of children to another body, which it has. So what provision of this act are you saying has been illegally breached?
My lordship, they breached the act by, although they handed over to Dr. Barney's the fact that no one should be treated inhumanly. Under the Children's Act, Dr. Barney's has deprived the appellant from his human rights, from his essential human rights.
But doesn't the contract confer the power on Barney's to control the children? I mean, they can't be in a situation where here's some kids to take care of, and by the way, you can't control them.
Yes, my lordship, but controlling a person is essentially not meaning depriving him from essential rights.
Okay. So you're implying into the Children's Act an obligation
Yes, to do the best.
to abide by
Yes,
the convention and the human rights.
yes, my lordship. May I proceed?
So what's the link between illegality here and irrationality? So you're saying the same conduct
Yes,
is a breach of both.
yes,
Okay. Fine. Please proceed.
I'm obliged. I will now move on to the final point of my submission. May I draw my lordship's attention to divider C, yellow tab 8, paragraph 137 and 138 of the case Kucheruk and Ukraine 2011 52 European Human Rights Reports, page 28, decided in the European Court of Human Rights. Does my lordship have sight?
I do.
Does my lordship require a brief summary of the facts of the case?
Very briefly.
Mr. Kucherov was diagnosed with schizophrenia in 1998. In 2002, he was arrested but certified fit for his detention. On July 2nd, assaulted another inmate and was transferred to another medical wing. On July 8th, Mr. Kucherov became agitated, leading the staff to apply unreasonable force to restrain him. He was handcuffed and locked up and deprived from any of his medication. The plaintiff, Mr. Kucherov, succeeded due to the invasive breach of his human rights under Article 3, the prohibition of inhuman treatment. I quote, my lordship, Judge Lorenzen. The court recalls that Article 3 of the Convention enshrines one of the most fundamental values of democratic society. It prohibits, in absolute terms, torture or inhuman or degrading treatment or punishment, irrespective of the circumstances and the victim's behavior. Furthermore, I quote, in considering whether punishment or treatment is degrading within the meaning of Article 3, the court will also have to regard to whether its object to humiliate and debase the person concerned, and whether, as far as the consequences are concerned, it is adversely affected his or her personality in the manner incompatible with Article 3. This, my lordship, sustains the fact that the treatment by the staff at the European Convention of Human Rights 1950.
Well, let's take each of the problems that your client has drawn to the court's attention. So, firstly, he's locked in a room.
Yes.
Now, I think it's common ground between the parties that this is, or your client was, between the ages of 14 and 18, quite disturbed
Yes.
and had quite extreme behaviour. How does locking that person up in their room constitute degrading behaviour, degrading conduct?
Well, my lordship, referring to Judge Lorenzen's quote,
Yeah.
stating...
So could that arouse such feelings of fear, anguish, and inferiority, capable of humiliating or debasing the victim, and possibly breaking their physical and moral resistance.
It could, due to the fact that locking up a person, keeping a human being in a room by himself, knowing that the person has any kind of issues or aggressions, could lead to a personality change and to personal psychological injury.
And have you found a case in which someone being locked in their room is in of itself inhuman and degrading treatment?
My Lordship, I believe the case I've brought to the court's attention illustrates this very well.
So remind me, was this person locked in his room?
Yes.
And the problem was, however, that that person was a schizophrenic.
Yes.
So if you're a schizophrenic and you're locked in your room, that doesn't get rid of the voices in your head. That just locks you up in a room and potentially leads to quite a dangerous scenario.
But
this person, your client, does not have schizophrenia. He was simply had behavioural issues.
Yes, my Lordship. But I still believe that although in the other case the appellant was schizophrenic, he was still deprived of his human rights, even though he had a detected medical condition. They were not supposed to apply the force they did in order to restrain him, to lock him up. Furthermore, depriving him from any medication just enhanced the possibility of him gaining more aggressions, and his personality just changed and became like, sorry, my Lordship, his personality was affected, and this could constitute also in the physical injury he sustained by being restrained.
Okay.
My Lordship, this is how we feel and apply this quote of Judge Lorenzen of Article 2. My Lordship, have any further questions?
No.
May I refer my Lordship to Yellow Tab 9 of the case concerning the judgment? In a violation of Article 3 in respect of excessive use of force by the prison officers, and also under subsection 4 that there had been a violation of Article 3 in respect of the handcuffing of the applicant whilst in detention in the disciplinary cell. My Lordship, this judgment proves that there was in fact a breach of Article 3 under the European Human Rights Convention 1950.
And in what way am I meant to, under the Human Rights Act?
My Lordship, Dr. Barnes and his workers harshly detained, tortured and deprived the appellant of his basic human rights.
Sorry, he was tortured?
By the harshness of their actions.
Okay.
I would consider this falling under torture under Article 3 because it doesn't seem appropriate to restrain a young adult that way they acted, to lock him up.
Oh, it's the locking up that's torture?
The way, yes, my Lordship, that
Not the fact
that
they
also
start.
incorporates torture, but the way the workers at Dr. Barney's acted constitutes the main part of torture, following up the locking up, which is depriving him of his basic human rights. Does my Lordship have any further questions?
Yes, my previous question. What is the obligation on me in terms of You're quoting to me a case of the Strasbourg court. Okay, this is an English court. So what persuasive or other authority does it have over the Supreme Court?
We wanted to draw your Lordship's attention to a European court case to prove the fact how Article 3 and the breach of it is substantial and can be excessive on people's behavior and the following up decisions. That's why we necessary to show that not only in the UK, but also throughout Europe, Article 3 and its breach cannot be allowed.
Right. Thank you very much.
My Lord, it is for these reasons and those given by my learned senior that I urge you to allow the appeal.
Thank you.
This concludes my submission.
Yes.
If it pleases the court, I would like to offer my first submission.
Please do.
Much obliged, my lord. My lord, I submit that Dr. Barnes was not a public authority under Section 6 of the Human Rights Act 1998, so as a private body had no obligations under the Act. The Human Rights Act 1998, Section 6, can be found on Green Tab 5, should my lord need a reference to it. Does my lord have sight?
Yes.
Obliged, my lord. May I proceed?
Yeah.
My lord, it is evident that Dr. Barnes is merely an agent of the council and not a public body. My lord, I would like to reference the case of Housing and Regeneration Community Association Ltd and Donahue, 2001, England and Wales Court of Appeal, Civil Division, page 595, which can be found on Green Tab 1, highlighted in green.
Yes.
Does my lord have sight?
Yes. Yes.
May I proceed?
Yeah.
Would my lord benefit from a brief summary of the facts of the case?
Very brief.
A tenant appealed against the possession order under the Housing Act 1988, Section 21, granted in favour of her landlord, a housing association, which had been created by the local authority to take part in a takeover of its housing stock. Dee contended that the hearing should have been adjourned so that she could adduce fresh evidence as to whether P was a public body for the purposes of the Declaration of Incompatibility. It was held that the appeal was dismissed. My lord, Lord Wolfe states that there are many bodies which are required to act in accordance with public powers, duties and functions, but which remain essentially private bodies. Railtrack is an example. My lord, in application of the words of Lord Wolfe, it is evident the authorities such as Railtrack, there is a close relationship between Railtrack and public authorities, and Railtrack is effectively an agent of these public authorities. Lord Wolfe also states, found on yellow tab 2, first highlight in green.
Sorry, 1 minute.
This one.
Okay, can I just look at something? Okay, sorry. What were you saying? Highlighted at 2.
Yellow tab 2.
Right. And so this is Lord Wolfe again.
Yes.
Right.
A public body, in order to perform its public duties, can use the services of a private body. This further bolsters the idea that a private authority can be an agent of a public authority to carry out the purpose of the public authority. My lord, in application, it is clear that there is a contract between the council and Dr. Barnes, which does highlight an element of a close relationship. However, it is evident that Dr. Barnes shouldn't be considered a public body, as it should only be considered to be an agent of the council. There are many examples of this where a private body carries out a public function. A prime example being prisons. Prisons are often privately owned, but carry out a public function. The same can be said of British Telecom and the railway. The fact that these institutions carry out a public function and are still considered to be private institutions further bolsters the argument that Dr. Barnes is a private authority which carries out a public function. My lord, even though the council has, through the contract with Dr. Barnes, been conferred powers to Dr. Barnes, these powers only extend to the children it is relevant to. My lord, I would now like to reference the case of Foster and others, British Gas PLC, Volume 2, Weekly Law Reports, page 1075, which can be found on Orange tab 3, highlighted in green. Does my lord have sight?
Is this the same
This
case
is now,
as
this
the
is
EU
Foster.
case?
This is, yes, it is indeed, my lord.
So this is a judgment of the Court of Justice,
Yes, my lord.
which is not the same thing as the European Court of Human Rights.
Well, I chose this case because I feel it illustrates well the point I'm making with regards to the definition of public and private bodies.
So you're bringing into what is essentially a human rights case, this case, something from an EU jurisdiction.
Yes, my lord.
Why?
Because, as I say, I feel it illustrates the point I'm making quite well with regards to the definition of public and private bodies.
But what I'm struggling with is why is the definition of a public body for the purposes of EU law, which is very specific in order to delineate the relationship between individuals and the state in the context of a directive, why is that relevant to whether or not a public body should be considered in this case, which relates to the care of children?
Because it is actually, the relevance is in regard to the special powers, an element of the Foster test. And
But
if
do we not already have that in the Aston Canfler case?
but even
That
so,
your learned friend opposite quoted.
yes, my lord, yes, my lord. But
Are
I
you going to deal with that?
the Aston Canfler case,
Yeah.
it is not one of my authorities.
Okay. So, okay, fire away. Tell me about this Foster British Gas.
Would my lord benefit from a brief summary of facts?
I probably would, but let's not.
May I proceed, my lord?
Yes, please.
My lord, in Foster, Mr. Advocate General Van Gerven stated, on the basis of those considerations, the court has held in a series of cases that unconditional and sufficiently precise provisions.
Sorry. So you're quoting not just a different jurisdiction, but the non-binding opinion
This
of
is
an advisor to the court.
I'm actually just outlining the Foster test. The Foster test.
Oh, you think this is a good...
I just feel that
Good points.
it just illustrates the
I
point.
see, okay.
This is not.
Alright.
Sorry. On the basis of those considerations, the court has held in a series of cases that unconditional and sufficiently precise provisions of a directive could be relied on against organisations and bodies which are subject to the authority, which are performing acts within the public interest, are not necessarily. Sorry, my lord, I misquoted. May I please proceed again? On the basis of those considerations, the court has held in a series of cases that unconditional and sufficiently precise provisions of our directive could be relied on against organisations or bodies which are subject to the authority or control of the state or had special powers beyond those which result from normal rules applicable to relations between individuals.
Right.
And now, may I proceed with the relevance of this?
Yes, please.
I propose that Dr. Barnes does not pass the Foster test, as it does not have any special powers, as the powers with regards to the children are not only limited but delegated by the local council. Thus, by definition, Barnes is not a public body and thereby must be considered as a private authority. May I proceed?
Can we go back to the first case? That you
Donahue.
quoted? Yes. And you quoted Lord Wolfe, I think it was.
Yes.
If I'm not mistaken. So, and you said there are many bodies that are required to act in accordance with public powers, duties and functions, but which essentially remain private bodies. Railtrack is an example. But then how did he go on to conclude? Did he then, I mean, I'm not quite clear as to the relevance of that, because that's just saying that they are a private body that exercises a public function.
Yes, my lord. And
So why can't they be deemed, for the purposes of the Human Rights Act, to exercise a public function?
because it would conflict. Sorry, may you ask the question again? Why?
Yeah, sorry, perhaps I wasn't clear. So, all this is saying is that there are some private bodies that carry out public powers and have public duties, which surely is their point.
Well, what I'm saying is that when I say okay, so I'll track back. When I say that the Dr. Barney's is an agent of the public authority, being the council. I'm merely saying that public authorities can use private authorities to carry out their function.
Okay.
And would my lord, may I proceed?
Yes, please.
Sorry, my lord. My lord, I would now like to reference the case of Crown on the application of Heather and Leonard Cheshire Foundation, 2002, England and Wales Court of Appeal, Civil Division, page 366, which can be found on pink tab 4, highlighted in green.
All three of you really like your pink today. Pink and yellow. Fire away.
Would my lord benefit from a brief summary of the facts?
Yes, please.
H, residents of a home for the disabled, owed and run by L, a charity, appealed against the dismissal for their application for judicial review.
Sorry, say that again. H was what and L was what?
H, residents of a home for the disabled, owned and run by L, a charity, appealed against the dismissal of their application for judicial review of L's decision to redevelop the home. H contended that the loss of their home was an infringement of their rights under the Human Rights Act 1998, Schedule 1, Part 1, Article 8. H argued that the provision of accommodation by L constituted the performance of a public function within the definition of Section 6 of the 1998 Act, and therefore its decision to redevelop the home was amenable to judicial review. The court considered whether the judicial review proceedings were appropriate for the dispute as to whether a body was performing a public function. It was held that the appeal was dismissed. My lord, may I proceed?
Yes.
I am obliged. Lord Wolf states, the fact that a body is a charity or is conducted not for profit means that it is likely to be motivated in performing its activities in the public interest. However, this does not point towards the body being a public authority. This clearly illustrates that charity organisations, like Dr. Barney's, which are performing acts in the public interest, are not necessarily a public authority. My lord, if I may use the University of Buckingham as an example of this. The university is a private body and is a charity, but performs a public function by educating students. However, yes, my lord.
Yeah.
May I proceed?
Yes.
However, some students receive student finance. The funding comes from the government. Thus, it is evident that the government involvement in private organisations does not make a body a public body.
But wasn't the point here that they're focusing on the activity? So here they're saying, if I've understood the case correctly, that giving someone somewhere to live isn't necessarily a public function, but taking care of children surely is.
I actually deal with this a bit later on, my lord.
Okay, fine.
Thank you, my lord. May I proceed?
Please.
So this dispels the argument that the closeness between Dr. Barney's and the council makes Dr. Barney's a public authority. It is stated in the case at hand that Camlington leased its residential care homes to Dr. Barney's, a charity which was established to run orphanages, and entered into contract with Dr. Barney's under which children in care, under the care of the council's statutory powers, will be housed and cared for by Dr. Barney's, in return for a payment in contract fee for each child. It is clear that these payments are not funding the charity itself, but each child in care. My lord, in consideration of Lord Wolf's words, this illustrates that even if helping to raise a child is deemed to be a public function, this does not necessarily make Dr. Barney's a public authority. My lord, the respondents propose that Dr. Barney's cannot be considered a hybrid body either. My lord, I would like to reference again the case of Housing and Regeneration Community Association Ltd and Donahue, 2001, England and Wales Court of Appeal, Civil Division, page 595, which can be found on yellow tab 2, highlighted in green. Does my lord have sight?
Yes.
I am obliged. This is the second highlight, my lord. Would my lord benefit from a brief summary of the facts?
No, thank you.
May I proceed?
Yes.
Lord Wolf states, an act can remain of a private nature even though it is performed because another body is under a public duty to ensure that the act is performed. In application, it is evident that Dr. Barney's donating money to orphanages is not necessarily a public function just because it is performed within the public duty of the council to fund orphanages. Thus, I propose that it is possible that Dr. Barney's function be considered a private one, and thus, if the nature of the act is private, by definition, Dr. Barney's cannot be considered to be a hybrid body. Does my Lord have any questions?
No.
My Lord, in short, for the reasons I have submitted to the court, we do not consider that Dr. Barney's be considered a public body and that it should be deemed to be a private authority. This concludes my submissions, my
Thank you
Lord.
very much.
Thank you.
If it please your lordship, my name is Tasmin Mia and I am appearing as junior counsel for the respondent. If your lordship could open the bundle to tab 0, you should have cited the skeleton argument. Does my lord have sight?
Yes.
May I proceed? I am obliged, my lord. For my submission, I will argue against the second ground of appeal against my client and submit that firstly, even if the Human Rights Act does apply to my client, there can be no violation of the convention rights to which the appellant is entitled. And secondly, that in the care of my client, the appellant did not experience treatment of inhumane and degrading nature. May I proceed, my lord?
Yes.
If your lordship could turn to tab 6 of the bundle, you should have sight of an extract of the European Convention on Human Rights. Does my lord have sight? May I proceed?
Yeah.
I request your lordship to turn the page over to view Article 8 of the doctrine. With your lordship's permission, I would now like to refer your lordship to Article 8 of the document highlighted in pink. I quote, "Everyone has the right to respect for his private and family life and his home and his correspondence. Also, there shall be no interference by a public authority with the exercise of this right except such as in the accordance with the law and is necessary in a democratic society for the protection of health or morals." It is clear from the article that, if for the protection of any individual's health, interference in the exercise of this right is permissible. My client could, with the powers conferred on him by Camdenton Council, restrict Mr. Brown's access to his family, if it's for his benefit. More so, it was initially found that the claimant's parents were of inadequate capability to be allowed the responsibility of their child, and therefore, for the safety and welfare of the child under the Children Act 2000, Mr. Brown was taken into the care of Dr. Barney's. And thus, for the protection of Mr. Brown's health, my client had restricted access to his parents. This therefore conveys that there was in fact no violation of Mr. Brown's convention rights to private and family life. My lord, indeed, the courts have a duty to respect the wishes of a child, but there are times when the court must act on behalf of a child for the betterment and welfare of the child in accordance with the jurisdiction of wardship. If your lordship return to tab 7, you will have sight of the Children Act 1989, Section 100, subsection 4b, on the restrictions on use of wardship jurisdiction. Does my lordship have sight?
Well, this isn't part of the case because the only relevant act, only two relevant acts we're looking at today are the Human Rights Act and the Children Act 2000.
I understand that fully. I just assume, I assume that this act can convey what or how my client was trying to take care of the child. He was trying to protect his health and morals.
I'm not going to entertain that. So can you please move on to your next submission?
Yes, my lord. If it pleases the court, I would like to offer my second submission.
Please do.
I'm obliged, my lord. If I could ask your lordship to turn to tab 6 of the bundle to give your lordship sight of Article 3 of the European Convention on Human Rights.
I'm familiar with it.
Article 3 of this convention states that no one shall be subjected to torture or inhumane or degrading treatment or punishment. The appellant has claimed that under the care of my client, he underwent inhumane and degrading treatment. The appellant, I would like to put to the court that my client had not committed any such violation on the basis that the appellant was a very disturbed and angry youth due to which he was frequently punished by being locked in his room and being denied meals. The appellant was also physically restrained and slapped by the members of the staff. However, this does not constitute of inhuman or degrading treatment. If my lord could turn to tab 9 of the bundle,
Okay.
I would like to refer your lordship to the case of Tyra and the United Kingdom reported in the second volume of the European Human Rights Reports for 1980, which was heard before the European Court for Human Rights. Does my lordship cite?
I do.
Would my lord like a brief summary of the facts of the case?
Briefly, yes, I think I know this case.
My lord, the applicant was a 15-year-old schoolboy who had been birched as a punishment for causing bodily harm to a senior pupil at the same school. Upon the assault, the applicant had been taken to the juvenile court and sentenced to 3 strokes. The applicant then applied to the commission alleging that the United Kingdom was in breach of Article 3. My lord, I submit that this case is applicable to the situation at hand due to the outcome of the judgment. Highlighted in pink, it shows that within this case it was found that contrary to Article 3, the punishment did not constitute either torture or inhuman punishment, since the applicant did not undergo suffering of the level of inherent in those notions. It was found in this case that a punishment would only be degrading and in breach of Article 3 where a person was humiliated. In being physically restrained and slapped, there is lack of humiliation to that level, thus casting more doubt on the appellant's claim. If my lord could turn to page 6 of this case, Tyra in United Kingdom, paragraph 29, your lordship will have sight of the relevant highlighted text.
Sorry, which tab?
Tab 9.
The same case?
Mm-hmm.
Right, oh, sorry, yeah. Whereabouts?
Paragraph 29.
Okay.
I quote, the court does not consider the facts of this particular case, does not consider that the facts of this particular case reveal that the applicant underwent suffering of the level of inherent in this notion as it was interpreted and applied by the court in Ireland and United Kingdom. This case held that the suffering occasioned must attain a particular level before such punishment can be classified as inhuman within the meaning of Article 3. Mr. Brown may have suffered, but not to that degree, which is where I wish to conclude that Mr. Brown hadn't suffered inhuman and degrading treatment in terms of Article 3, in the meaning of Article 3, because of the fact it wasn't up to that level.
Well, that case is talking about a particular type of practice, a single practice, that of birching. And that person received sort of 3 sort of strokes. But here, your client has been involved in 4 different things, which you could argue cumulatively amount to inhuman and degrading treatment. So it wasn't just one thing, it was 4 things. They were prevented from seeing their family, they were prevented from coming out of their room, they were slapped, and they were denied meals. So surely that's an important difference between the 2 cases.
It is indeed, but my point which I'm trying to bring to the court is that though they may have been 4 different things, and yes, birching is completely different to being slapped and kept locked in and then denied meals, but I believe that if you judge it individually, if not even collectively, it still doesn't amount to the level of humiliation, of suffering that Mr. Tyra did in the case. Also, Mr. Brown's suffering, I say, wasn't to that degree, was because Mr. Tyra, when he was birched, his skin may not have split, he may have not been injured to that degree, but his skin rose, which is, upon birching, his skin rose, so it was visible, and I believe that though Mr. Brown had been slapped, his suffering was more somatic than physical.
But isn't mental harm part of, if you're I'm no expert, but if you could torture someone, the ideal way to do it would be a way that doesn't leave a mark, a physical mark, but it's surely the psychological effect that's the key criteria.
I understand that, and I believe that is very, very valid. I think that Mr. Brown hadn't suffered that much mentally, and torturing, I don't believe he was.
Okay, in terms of inhuman and degrading treatment.
Um,
I mean, it's a different level of harm. Okay, so there's a continuum. This is nothing, I suppose here's a headbutt, and this is actually attaching electrodes. So along that spectrum, where would you say Tyler was, and where would you say the appellant was? More headbutt than electrodes, or more here to there? Where do you think?
probably more headbutts
What here?
around the
Who,
middle.
Tyler or
No,
the
no, no,
appellant?
the appellant. And I think Tyra was a bit
So you're
further.
saying that a headbutt is not inhuman and degrading treatment when delivered by a public authority? Assuming it is.
I believe it is degrading, but
Right.
in the case, it would be considered degrading and inhumane
Right.
if there was a level of humiliation involved.
Okay.
I assume from the facts,
Mhm.
Mr. Brown wasn't humiliated. Therefore, there was no degrading nature in his treatment.
Mhm. Okay, thank you.
For the reasons set out above, the respondent would respectfully request the court to dismiss the appeal.
Okay.
Thank you.
Would either of you like to make a response to what you've heard from the other side in respect of either of your submissions?
Yes, my lordship. In considering inhuman, degrading, and humiliating, which was put upon it, denying meals, locking him up, restraining him in order to lock him up, does in fact, personal level, and it can be humiliating on the basis that it might have mental, physical, and psychological consequences for the appellant.
Thank you very much.
Thank you.
Okay, so I will take some time to consider, 5 minutes or so, and then I'll be back.
All right.
All rise.